Now, can you sue to recover that loss? That is the question here. So that means here you are seeking the help of a professional. You are seeking the help of a professional. The professional is advising you. Based on that advice, you are acting upon, and you suffered a loss. And you suffered a loss. Can you sue that professional? It could be a doctor, it could be a lawyer, it could be an architect, it could be an engineer, can be a chartered surveyor, can be any profession, including estate agents here. Can you sue them? That is the question that we are going to look on professional negligence. Okay, now here very, very important here when you're talking about professional negligence here. Let's say you are meeting up your friend. Let's say you are meeting up your friend and he's a doctor and he's giving you some advice. As a friend, he's giving you an advice. You are relying on that advice and doing certain things. Or you are seeing your friend who's a lawyer and you are seeking his advice as a friend, not on a professional capacity, as a friend. And he's giving you some advice and you suffered a loss. Can you sue him? So here, in that situation, you cannot sue because he's giving you an advice as a friend. But here we are talking about professional capacity where you are making a payment, a professional fees. If you are paying a professional fees and the person is advising you based on the fees which you have paid him and you have acted on that advice and you suffered a loss, then in this situation you can sue. You can sue for whatever loss, damage, or injury suffered because of the advice you relied on. Because of the advice you relied on. Example, okay, you're seeing a lawyer, and he's advising you. Based on that advice, you acted and you suffered a loss. Can you sue? Of course, you could sue because that professional knew that you are going to rely on that advice. They knew that you're going to rely on that advice and you're going to act upon. And if you suffered a loss, then of course you can sue that particular professional to recover for whatever loss, damage, or injury which you suffered. Okay, now going back here, yeah. So, hello, Sofa, is it clear?
Yes.
Clear, yeah. So here, so earlier last week and this week, what we're going to look in here, the elements needed to sue that professional is the same. It's the same, it's the same. That makes no difference if you are suing under professional capacity or on non-professional capacity. The elements are still the same. The elements are still the same. Okay, first of all, of course, let's say you relied on an engineer and you suffer a loss. Of course, you will sue that particular engineer. Okay, in order to sue that particular engineer, first of all, you need to establish that that particular engineer owed a duty of care towards you. That is the first thing you need to establish, that that particular can be an engineer, can be a lawyer, could be a doctor, could be an architect, could be a chartered surveyor, that he owes a duty of care towards you. That's the first thing you need to establish, that he owes a duty of care towards you. Okay, how would you going to establish duty of care here? How you are going to establish duty of care here? Hold on here, uh, somebody is trying to admit, yeah, okay, Joshua, okay, right, admitted, correct. Okay, now how are you going to establish? Is it the same? Okay, how would you establish duty of care? How do you establish?
I pay him professional fee and he owes me a duty of care.
Okay, you are paying him a professional fee, so therefore he owes a duty of care towards you. Am I right? Because you are paying a fees. He's not giving you advice free, but he's charging a professional fees. The moment he charges a professional fees, then he knew that you are going to rely on that particular advice and you're going to act upon. Am I right? So that's the first thing you need to establish you that he owes you a duty of care because you are giving him a professional fees. Okay, once you have established that, the same thing applies to even lawyers. Yeah, if you are seeing a lawyer for an advice, of course you are paying a fee, a legal fee to the lawyer, and the lawyer knew that you're going to act on that particular advice which he's going to give you. He knew that, yeah. So if anything goes wrong, then you could sue him because there is a duty of care owed by him towards his clients here, towards his clients. True, isn't that? Okay. So once you have established that, okay, here only, bear this in mind here, here you only owe a duty of care based on professional fee. If you did not pay him, let's say he's your a lawyer friend or an architect or a or an accountant, and you are going for a evening meeting, not a meeting, a gathering, in a in a pub or in anywhere, for maybe playing football in the futsal or whatever, you are meeting up, and then you're asking him some advice, as a friend, and he's giving you. Now, in that situation, if you act upon his advice and if you suffer a loss, obviously you cannot sue him because he's giving you advice not as a professional under professional capacity, but as just as a friend, just as a friend is giving advice, right? So obviously, because there is no contractual fee or relationship, so therefore you'll be unable to sue him unless and until you have seek a second opinion. Maybe he has given you some advice as a friend. Maybe you go and see another professional to say whether whatever advice he has given him is it fair or is it uh, true or whatever, that's a different case. Yeah, but here it has to be a professional fees. If there's no professional fees, obviously there is no duty of care. Yeah, and second thing you need to establish is that you have relied on that particular advice. You have relied on that particular advice, and because you relied on that advice and you have acted upon and you have suffered a loss, you must show proof that you have relied on whatever advice which he has given him. But let's say he has given you some advice, professional advice, but you did not follow that professional advice, but you have done it differently, then he is not answerable. Then you cannot sue him. So, as a client, you could only sue him if you have acted on whatever advice he had given you. Normally, when a professional were to give you an advice, they would be giving advice in writing. They would be giving advice in writing, and you have acted upon that advice and you have suffered a loss. So you must show proof that you relied on his advice and have acted according to his advice and carry out things according to his advice or to his opinion which has given you. That you need to establish also. So here it is the duty of the client, that is the plaintiff, yeah, to establish that you have acted 100% on his advice. Let's say you have acted only 50% on his advice and another 50% on advice given by your other friends, professional without fee, and the whole thing got messed up. Then, of course, you will be unable to sue him because you did not follow whatever instruction or opinion which he has given you. So here, very, very important, you need to show proof. If you fail to show proof, if you fail to show proof, then obviously you would be unable to sue him, unable to sue him. Yeah. And thirdly, you must also show proof that you had suffered a loss due to that advice which you have followed. Okay? So you must show proof of the loss that which you have suffered due to the advice which you have followed. If you could not show proof of whatever loss or damage which you have suffered, then you will fail in your action. So here it is the duty that you must show proof that you have suffered loss. Like example, medical.
Sorry, sir. Sorry, sir. Can you let Chloe in?
What's that?
Chloe, can you let
Yeah,
her
hold on.
in?
Yeah, hold on. Okay, okay, sure. All right, done. Okay, so now going back here, you have to show proof that you have suffered a loss. It can be any loss, it can be any loss. It can be minor loss also. But as long as you could show proof that you have suffered a loss. Suffered loss, not necessary, must be physical. It could be in other form also, mental also can. Okay, it could be in money form, it could be to your reputation, it could be any form, but you must show proof that you have suffered a loss. You must show proof that you have suffered a loss. Example, yeah, going back on medical. Okay, medical, you have to be very, very careful, especially on medical, yeah, showing proof of suffer of loss or whatever, yeah. Normally, what the doctor will do is that before he perform a surgery, let's say you are going to see a doctor, a surgeon, and he's performing a surgery on you. But before he do the surgery, normally he will get a consent from you, a signature from you that you have agreed to undergo that particular surgery. And also he would advise you what are the chances of you recovering and what are the chances that it may go wrong or could be some side effects due to that surgery. He would have briefed you everything and then he would have given us you to consent to it here. Now, so here very, very important is that yeah, especially on medical negligence here, if very important, yeah, if the doctor had followed if the doctor had followed all the standard procedure, if the doctor has followed all the standard procedure of the surgery, the normal method or the normal procedure he has followed in doing the surgery, which all doctors will do, the standard procedure, yeah, has followed that, and based on that procedure the outcome is different. Let's say you have gone unconscious or you have gone paralyzed, then obviously you would be unable to sue the doctor because the doctor has followed the standard format, standard procedure and done the surgery. And because something has gone wrong, you can't sue him because you have already given him the consent because he has already explained to you what are the risks involved, and what would be the side effects and all the things here. But
Teacher,
ah
now is another point, right? The fourth point, right? Or
no,
is
no,
there another?
suffer is a third one. Okay, if the doctor did not the standard procedure, if the doctor did not follow the standard procedure, but he wanted to follow his own method, yeah, he feels more confidence here. And if anything happens, then here we call it a medical negligence because the doctor did not follow the standard procedure. So he has bypassed the standard procedure, and he has followed his own procedure of doing. He feels he's more comfortable with that procedure, which normally no reasonable doctors or surgeons would be following, and he has followed that. A shortcut, let's say, a shortcut. Then that is what you call as a medical negligence. Then you would be able to sue that particular doctor. You'll be able to sue that particular doctor. Okay, now you see here, going back, I did mention here, okay, the impact there might be a loss suffered by the doctor, right? By the patient's right. Okay, sometimes here you have to look also into this situation, especially medical negligence here. Sometimes it's not a standard for all patients. Let's say this patient is suffering from other illness. This patient is suffering from other illness. Yeah. Okay. Let's say he's having a diabetes, or he's having high pressure or whatever. Yeah. Normally doctors would not perform surgery if you're having pressure high. Normally when the pressure is low, only then they will perform the surgery. If let's say this doctor has performed the surgery while your pressure is high, then it's also a medical negligence, because normally doctors would not do any surgery if you're having either fever or flu or pressure is high. And also, very, very important, your diabetic level, or maybe 5.6 or the maximum 6. If below that, then they will perform the surgery. If your diabetic sugar level is very high, they also would not do a surgery. But let's say this doctor ignored that and performed the surgery, and you have gone into coma, then you could sue that particular doctor under medical negligence. Because you see, sometimes certain patients will be prone to certain illness, and because the surgery would have aggravated the whole situation, would have caused him to go blind or whatever. Yeah, in that kind of situation, it's quite difficult also. Like you see, as what you all can see now, most of the the patients who are dying of COVID-19 now, even though I think if I'm not mistaken, around 340 Malaysians has died because of that COVID-19. Am I right? But if you were to analyze and see, most of them who died here, one is either having a diabetic or high blood pressure or prone to heart diseases. These are the category of people, and also most of them are above the age of 60 or 70. Am I right? Because the immune system is very, very weak, right? So normally that's why your doctors, especially they be very, very careful when they are doing surgery on this category of people, because they know the risk is very, very high. That's why they will explain to the client or the next of kin to the client what are the chances of recovery from this surgery. Are you following here? So medical negligence, going back on medical negligence, is very, very, very important, Okay, I'll come back to some cases on medical negligence later, Okay, now, even accountants, let's say you're going to an accountant to get some advice, and he has given, or a tax consultant has given you some advice wrongly, and you have suffered a major loss in your business, then you could sue him also. That you could sue him also on that, Okay, especially professionals. When you're talking about here when you're talking about professional negligence, most of the time they refer to medical negligence. That is the main cause, medical negligence. Because otherwise, for others, normally they'll seek for second, third opinion. Because here, when you talk about medical negligence, your life is at stake. Not only your life is at stake, sometimes you could go paralyzed, sometimes you can go into coma for years, these kind of things. So that's why they are very, very careful, especially on medical negligence. Others like lawyers, and surveyors, architect, that is more on money damage, money loss, still can be recovered back. But if your health is damaged, let's say you've gone paralyzed for the rest of your life, or you have gone into coma, then obviously money cannot do justice. Even though money, yes, you can claim money, but what's the use of getting money but end of the day, your health is gone for good. Am I right? So that's why doctors also very, very careful in doing surgeries, especially if they are if they know that this person are very prone. The same thing even applies for real estate agents, or even brokers. Okay, what kind of negligence can be done by real estate agents or brokers? Okay, most of you all are real estate agents, right? Okay, tell me quickly. Any one of you can tell me? Hello? Hello, can you hear me?
The wrong information.
Okay, what kind of wrong information are you talking about? What kind of wrong information are you talking about?
Especially the land, I think maybe you think you are selling all this land, but actually after you sold, maybe it's the other land didn't do the land surveyor.
Okay, all right, okay, right. Any other than that? Other than that? But most of the thing, real estate agents or brokers, failing to reveal a known property defect. They'll hide what are the defects in that property. Am I right? Because they know that if they were to highlight what are the defects in that property, then they would be unable to sell that particular property. Am I right? True, isn't it? The defects in the property could be structural defect, because structural defect quite difficult to, unless until you bring in a civil engineer or structure engineer to do the structure of the building. Am I right? And these kind of things, could also. But going back on the freehold leasehold, that shouldn't be a problem because it's clear cut in the thing itself. It will reflect what is freehold and what is leasehold and what is TOL and all the things. Am I right? That is a clear cut. Yeah, but sometimes the estate agent would not reveal what are the issues on caveat. You know what's a caveat, right? Hello?
Yes,
Have you heard? Okay. Yes. Who's the person who said yes? Yeah.
Janice.
Dennis, can you explain to me what's your understanding of caveat?
My understanding of caveat is someone actually stop to do actually issue the document to the court so that you cannot sell the house.
Why you cannot sell the house? Why?
Maybe that actually have some issue about the owner with the someone actually do the caveat.
Okay. Normally, why do a person enter a caveat on that particular property?
Maybe they have owning people money, I think.
Okay, because there are a few types of caveat. Registrar's caveat, private caveat, and a trust caveat, and a lot of caveats. Normally, example, a simple caveat I tell you, sometimes, what will happen is that, the father, will be transferring the property only into one son's name, and that father has three sons all in. So the two sons were unhappy that the father has transferred the property into one son alone and ignoring the other two sons. They are saying that they also have the interest in father's property. They will put in a caveat preventing the one brother from selling off the property. Could be a situation, Could be another situation, Let's say A is the owner of the property. He has taken a loan from somebody and unable to pay. So that person knew that the only way for him to recover the money is preventing him from selling off the property. So he'll enter a caveat in that particular property. That means he also has an interest in that particular property. So that means this person, the owner of that property, has to clear off this person before he could sell off the property. Thankfully, when we do on property law, you do all these things, caveat and all the things in detail. So we don't get into that now. Okay. So now what are the situations here where you, as a real estate agent, you give advice wrongly? What kind of situation can be where it could cause a loss to the future buyer? What kind of situation do you think? Let's say in that particular area, there is a mapping to say that they're going to demolish all that particular area and they're going to come up with a new hospital in that particular area. And you knew about it and you have failed to inform the new buyer. Are you answerable? You have the knowledge, but you have failed to inform the new buyer about it. Because at the end of the day, you're only interested in your commission. But you're aware of that. Can that new buyer sue you? Knowing that you knew it and you have failed to inform him, he would have told you, he wouldn't have purchased that particular property. What do you think? Boleh atau tak boleh? As an estate agent, what do you think? Hello?
I think can.
Yeah, because most of the estate agents here, they would not reveal if they know that it's going to be a detriment to them, yeah, in disposing of the property, they would only reveal whatever which is going to benefit them. Am I right? So, as an estate agent, you're a professional, you have to be very, very transparent in whatever things which you are doing. Am I right? True, isn't it? So, now going back here, see, nothing much on professional negligence. Yeah? Still, the elements to prove still the same. Still the same. But the only thing you need to establish that there is an advice given under a professional capacity. So that means here, you as a professional, you owe a duty of care towards that particular client or towards that particular patient because you are collecting a fee. So therefore, you knew that this particular person is going to rely on your advice and going to act upon. If anything goes wrong, then you are answerable. Then you are answerable. Otherwise, you are not answerable. Otherwise, you are not answerable under professional capacity. Yeah. But if you have to see most of the cases here on medical negligence, I don't want to touch much on medical negligence here because it doesn't relate much to your failure. But then again, the whole professional negligence comes into that particular area. Okay, now another question here. Other than these professionals here, what about learner drivers? You are a learner driver. Let's say you are a learner driver, yeah? You are a learner driver and you are driving the car. And beside you, there is a trainer. You go and knock somebody and that person suffered injury. Now, can that person sue you? Cannot. What do you think?
Sir, can you repeat again? I not really understand.
Okay. The question here is this, yeah. You are a learner driver. You are learning driving, yeah. And beside you, there's an instructor. That's an instructor sitting beside you, and you are driving. And suddenly, you did something wrong, and you have knocked down somebody, and the trainer or the instructor suffered injury. Can he sue you? That's the question.
No,
Why?
because he's the one got the duty of care.
Who has the duty?
I'm learning, so he should be the one responsible for the safety.
Okay. Now let's say, yeah, the instructor is sitting beside, and you are driving a learner driver. You are driving, and you go and knock and kill a third party or damage a third party's property. Now, what about in this situation?
I think it's
What about in this situation?
It depends on if I got the intention to kill someone or I didn't.
Let's say so here there's no issue of intention here. Of course, you are a learner driver, right? You are a learner driver. Okay. So would a learner driver have an intention to kill any other person? Obviously, no, isn't there? Maybe perhaps he's not skilled enough, he's not skillful enough to drive, or he has been careless or reckless, he has injured somebody, am I right? Okay, in this situation, can you say that, okay, let's say you are having a L or P, yeah? P is what? Yeah, what is P now? Yeah, P is that you have already passed your driving test, right? P.
Yes.
L is those who are learning, but P is the one who has already passed, but still they have to have P for the next 2 years, am I right? Or something like that. 2 years, is it 2 years?
Yes.
Okay. Now, let's say you're having P and you're driving your car on your own, yeah? You're driving your car on your own and you're knocking down somebody and injuring somebody or damaging a third party's property. Can you put up a defense to say that you are still in the process, you are not an experienced driver, but you are still a learning driver, therefore it is a defense for you? Can you justify that? Can or cannot? Can you go to a courtroom and say that, look here, I'm just a learner driver, I've done a mistake, I've damaged or killed him? Is it a defense? What do you think? What do you think?
I think no.
Okay. Why? Okay. Yes. Yes. Somebody. Why you say no?
Because I already learned all the lessons and I already take the exam, so I should have the basic knowledge of the driving skills.
Basically. Okay. But you see, but the law says this here. Bear this in mind here. What the law says is here. Once you have obtained a driving license, whether just qualified or 1 week or 1 month or 2 months or less than 2 years, but you are expected to be as skillful as an experienced driver. So that means, yeah, it is never ever a defense for you to say that I'm a learner driver, so therefore I've killed him or I've damaged his property. It's a defense for me. No. Once you are qualified driver, you are expected to be competent as any other drivers. So it is never ever a defense to say that you are a newly qualified driver. It's never a defense here. Once you're on the road, you are expected to be as any other experienced drivers. The same thing applies for doctors. The same thing applies for doctors. Yeah. Can you say, I'm just I just qualified as a doctor, so I given him a wrong treatment and he has died. So I'm just a newly qualified doctor. So it's a defense for me. Can you say that? Is it a defense for you?
No,
What is it? What do you think? Huh?
no.
Okay. One person says no. Any others? Any others, please? Hello? Any others? So here, that is the reason, yeah. Okay, that is the reason why, yeah, medical degrees, yeah, they don't have first class honors, second class upper, second class lower, third class. They don't have a medical degree. Either you're competent or not competent. Once you graduate, you're competent. That means, yeah, you're expected to be as an experienced doctor. You cannot raise a defense to say that I'm a newly qualified doctor, so therefore I was unable to give him a proper treatment. It's never ever defense. So you're expected to be as a competent. Once you're qualified, you are supposed to be a competent doctor. It's never ever a defense. It never ever a defense. But only for directors. Hello, only for directors. Yeah, directors of company. Yeah, there is a loophole. Okay, you cannot equate. You cannot equate that all directors of the company must have the same competent or capability. You cannot standardize. You cannot standardize. The duty of care, the duty of care of a director goes according to his qualification and experience. You cannot equate a director of a company with 20 years experience as a director and a newly qualified director. And also you have to take into consideration the qualification. If let's say you are a director of a plastic company, let's say a plastic company, and you don't have any paper qualification. Okay, you do not have any paper qualification, but you newly joined as a director of that particular company, a company which specializes on rubber materials. Yeah. Okay. And then another company, a director with 20 years experience, a plastic company also, yeah, with a 20 years experience, and he is having a degree in, let's say, in polymer science, a degree in polymer science. A degree in polymer science means they study on rubber technology. Okay, so this guy, 20 years as a director, working as a director in a plastic company, but he's also having a degree in polymer science on plastic. And the other company, a director, newly qualified, but do not have any experience. So you cannot equate. Both of them should have the same standard of care and diligence. So as far as directors is concerned in Malaysia, under the Company Act of Malaysia 2016, what they're trying to say, the duty of care of a director goes according to his qualification and experience. It goes according to his qualification and experience. You cannot standardize that all directors must have the same standard of care and duty. No. But it only applies for, it doesn't apply for doctors and learner drivers. It doesn't apply for doctors and learner drivers. It doesn't apply for them. Once you are qualified, you must be competent as any other person. You cannot say, I'm a newly qualified doctor or I'm a newly qualified uh, person with a driving license. So it's a different for me. You cannot say that. Okay, any questions so far, please? Any questions so far? Any questions so far before I go into some of the cases here? Before I go into some of the cases here. Okay, now for learner drivers here, listen here. You know why I'm giving all these cases here? Because still Imperial have not finalized here. But what I know is you guys are going to have an assignment to do. Yeah. In fact, I did mention about this last week also, isn't there? Shelley, can you hear me?
Yes.
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 Okay. Okay. For these reasons, you need to know all these things here. That's the reason why I'm giving all these cases here. For learner drivers here, take down this case. Noor Muhammad.
How to spell?
Noor Muhammad. Mohamad.
Sorry, teacher, can you repeat again? Because just now got
Okay.
feedback.
Okay. Noor, Noor, Noor Muhammad versus Palanivel, Palanivel, and others. Okay. Okay. This case here for learner drivers, yeah.
Sir, there's another student called Lao Chun wanted to join by you. Can you accept him in?
Okay.
Thank you.
Okay, done. Okay, learner driver, yeah. You got it? Okay, this case also you can apply for vicarious liability. This case, you all know what's vicarious liability, right? Hello? Shelley, can you hear me?
Yes.
What is
Yes.
vicarious liability, Shelley?
Vicarious.
Tell me quickly. Don't
I
refer
don't
to
remember. I don't remember.
Okay, anyone can help me quick? Anyone can help me?
Is it about the employee that
Yes. You see, in this case here, you can also apply for vicarious liability. Yeah. This case here, the Nur Muhammad case here, you know what the court held in this case here? The court held the owner of a car. The owner of a car is vicariously liable for the negligent driving of the learner driver, as he is the owner, has an interest or concern in the purpose for which the vehicle was lent, which was enabled to drive or to learn to drive. So that means here, if you are the owner of the car, you have given your car to use by a learner driver, and if the learner driver go and knock down someone, then you are vicariously liable towards the third party. So that means, yeah, let's say the learner driver go and injure somebody or damage a third party's property. Yeah, you as the owner of the vehicle, you are vicariously liable towards the third party for the negligent driving of the learner driver, because you have the interest in the car. You are vicariously liable towards the third party. Is it fair or not fair? Is it fair or not fair?
Sir, repeat.
Okay, what I meant is, yeah, in this case, Nur Muhammad versus Palnivel, yeah, what the court has held in this particular case, let's say you are the owner of the car. Let's say you are the owner of the car. You have given that car to use by a learner driver. You have given your car to be used for learning. And that person who's learning, using your car for learning, has gone and damaged a third party's property while he's learning, or he has injured a third party. So you as the owner of the vehicle, you are vicariously liable towards the third party for the negligent driving of that learner driver. Is it fair or not fair?
Fair.
Fair kan?
Fair.
So okay, I'll give you another case also. Yeah, Wong Chu Yong, Wong, W-O, this is also for learner driver. Yeah, Wong Chu Yong versus Safety Insurance Company Limited versus Safety Insurance Company Limited. You got it? Hello?
Yes. Yes.
Got it, yeah? So that are two important cases you need to know on learner drivers, yeah? Okay, for medical negligence, yeah? For medical negligence, yeah? This is one of the very, very important case which lay down the law for medical negligence, which you need to know here. Even if you Google here, you would get the facts of this case here. Go and do some work on this case here. I'll tell you the name of the case here. Bolam, B-O-L-A-M, B-O-L-A-M versus Friern, F-R-I-E-R-N, F-R-I-E-R-N, Hospital Management Committee. You got it? Hello? Dapat atau tidak?
Yes. Dapat.
Got it, yeah? That is one of the very, very, very important case. Whether you like it or not, you need to know on medical negligence here, because this is a case which lay down what are the guidelines needed to establish medical negligence here. Okay, and you can also relate one Malaysian case here for medical negligence here. I give you the case. Kamalam, K-A-M-A-L-A-M, K-A-M-A-L-A-M, anak perempuan Raman, R-A-M-A-N, versus Eastern Plantation Plantation Agency, Eastern Plantation Agency, Eastern Plantation Agency. Okay, that you could apply for medical negligence also. That particular case you can apply for medical negligence also. Yeah, you can apply that case for medical negligence. These are the two cases which you could refer to for medical negligence, for medical negligence. Yeah. Okay, now going back here, going back to the situation I just mentioned earlier. Yeah. Okay, you remember the other day I did the case of Bolton and Stone, right? With you all, right? Bolton and Stone. I did the case with you all, right? Bolton and Stone. Am I right?
Yes.
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 Okay. What was the purpose I given you all that case? For what purpose I given you all the case? Do you all know?
Is it degrees of the
Ah, correct. The degree, am I right? Because that is the case which the judge said that you have to see the degree, how frequent it takes place, am I right? If it's very, very rare, then no breach, am I right? If it's frequent, then it's a breach, am I right? To establish, isn't it? So that means they look into what was the degree of the frequent that things happen, am I right? If very rarely it takes place, then cannot establish for breach, am I right? So if it's frequent, then you establish for breach, am I right? That's what I did mention to you all, isn't there? True, isn't there? Okay, so going back on this thing here, the only thing is that all professionals are liable. All professionals are liable in immaterial, whether it's medical negligence or by defect by the engineer or breach by the engineer or architect, whoever, as long as they have taken a professional fees, as long as they have collected a professional fees and have given them advice, and if they suffer a loss, then obviously they are answerable. They can be sued by their clients. They can be sued by their clients. Yeah. So the only exception here is the learner drivers. Obviously, they cannot. And also, yeah, company directors, because company directors, they didn't standardize. They said it goes according to their qualification and experience. It goes according to their qualification and experience. You cannot standardize that all directors must have the same standard of care and breach. Am I right? That's fair, isn't it? Okay. Now, going back on to the other day, yeah, did I given you all any cases for your contributory negligence? Because you all need to know what is contributory negligence. I did mention about contributory negligence the other day, right? You all know what's contributory negligence, right? Hello? Hello? Can you all hear me?
Yes.
Okay. Have I given you all any cases for contributory negligence? Because contributory negligence comes under Section 12 of the Civil Law Act of Malaysia. I think I did mention that also last week,
Yes.
right? Okay.
Yes.
So, but I've given you all some cases. Have I given you all enough cases? I give you all another two more cases here. I give you all another two more cases here. Please take down these two cases here, because these two cases are important cases here on contributory negligence here. Okay. Wu Peng Chong. Wu, W-O-O, Peng, P-E-N-G, Chong, C-H-O-N-G, versus Malayan Tobacco Distributors Limited. Wu Peng Chong versus Malayan Tobacco Distributors Limited. You got it?
Yes.
Okay, another case, yeah? Another case. I give you another case. So, yeah. Ong Tek Seng. Ong, O-N-G. Tek, T-E-I-K. Seng, S-E-N-G. Versus Ho Siu Chi. versus Ho Siu Chi versus Ho Sui Chi. Got it? Okay, this all, so that means these cases are given you all now, yeah? This all, the plaintiff also has contributed towards the injury. So if, okay, what is the situation here? If the plaintiff also contributed towards the injury, yeah, what will happen, yeah? What's the outcome? Shelly, what's the outcome, Shelly?
The outcome of what?
Okay, my question is, yeah, if let's say the plaintiff also has contributed towards the injury, if the plaintiff also has contributed towards the injury, what is the outcome? What is the outcome if the plaintiff also contributed towards the injury? What's the outcome?
Then
Ah,
then he can minus off the things that he need to pay. Yeah.
okay, so that means, what's that? So that means, yeah, whatever he has contributed, the judge would minus off whatever he contributed and he will only get the balance, am I right?
Yes.
Okay, that is what. So contributory negligence is not a total defense, but the quantum of damages awarded would be minus, and that person would be getting whatever he has the balance. Am I right? Okay, for contributory negligence, can it applies for drugs and drinks? Okay, let's say you have consumed alcohol, you have taken drugs, and you have drove and somebody has knocked you, but you are under the influence of drugs or alcohol. In that situation, is it a contributory negligence also? Because you are drunk, yeah, you know the other person is driving the car recklessly, but you would have avoided, but since you are drunk, you didn't avoid it.
Yes.
Okay. For this situation here, I'll give you one case here. Khoo Teck Hui. Khoo, K-H-O. Khoo Teng Hui, T-E-N-G. Hui, H-O-O-I. Versus British India General Insurance Company.
So can you repeat again?
I'll repeat again, yeah. Khoo, K-H-O. Teng, T-E-N-G. Hui, H-O-O-I. Versus the British India General Insurance Company Limited. You got it?
Yes.
Okay. Another case here. This is also driving, but turning, never follow the traffic instruction. That also can be a contributing negligence here. For that, I give you a case. Maria binti Muhammad. Maria binti Muhammad versus Abdullah bin Daud. Versus Abdullah bin Daud. Versus Abdullah bin Daud. Okay, that cases all you could use it for your contributory negligence. Other than contributory negligence, what else did I mention is also a defense? Other than contributory negligence, any other defenses? Other than contributory negligence, any other defenses? Any other defenses other than contributory negligence? This defense. Okay, these defenses for who? These defenses for who?
For the defendants.
For the defendant, am I right? It's for the defendant, am I right? Obviously, it's for the defendant, am I right? Okay, other than contributory negligence, what else could be? Okay, I'll give you one more case here. One more case here. Not wearing a safety helmet, Not wearing a safety helmet here. I'll give you one case here. It's also a contributory negligence, right? Wong Agan Wong, W-N-G-R-A-H, Gan, G-A-N, versus Chan Swee Yo. Chan, C-H-A-N, Chan Swee, S-W-E-I, Yo, Y-U-E-H, Y-U-E-H. That you could use it also for your contributory negligence, because contributory negligence is one of the main defense for that defendant, yeah. But it is only to reduce the quantum of damages. It's only to reduce the quantum of damages awarded to the plaintiff, because he also contributed towards that particular injury, loss, or damage. Am I right? So it is not a full defense, but it is a partial defense where it reduces the quantum of damages awarded to the plaintiff. Am I right? Okay, other than that, is there any other defense for the defendant?
Yes.
What other defense I did mention the other day?
Res ipsa loquitur.
Res ipsa loquitur, right?
Yeah.
Res ipsa loquitur, right? Okay, res ipsa loquitur for what? What's the purpose of res ipsa loquitur? So there the plaintiff not necessarily must show proof of, not necessary to show proof, right? But the circumstances of the case is referring to the plaintiff. Am I right?
Yes.
Am I right? Okay, just give me a 5 minutes here. We take a 5 minutes break and I'll come back. Just give me a 5 minutes break. Okay, just a 5 minutes.
Okay.
Bye.